Thank you very much. Good morning, all distinguished participants, distinguished presenters. Young man, the only thing you forgot was Paula Vanessa Llewellyn. I love my middle name. I think that this conference has come at a very good time in our history. And of course, we know the big elephant that is in the room, but none of us here should be intimidated by it, because it's a conference like this that helps to reaffirm, reassure all of us that we are capable. And one of my favorite phrases, that after this conference, our testicular fortitude will be further entrenched to meet the challenges. Now, prosecuting financial crimes, I understand I have about 20 minutes, so I'm going to go through quickly. Okay. Who is the prosecution? The prosecution means not just the prosecutors who appear in court, but includes persons such as police officers and other state officials connected with the investigation and conduct of the case against the accused person. And this was reformulated by Mr. Justice Panton in the Jamaican Court of Appeal in a case involving a police officer as the accused, Harry Daly, and the Queen. So it means that even though the investigator may think, this information here that I've gathered, this statement, this video, this CCTV reel, it's not relevant. If the prosecution does not disclose it at a later date, that non-disclosure after a conviction in the Court of Appeal and the Privy Council, we can pay the penalty for it and the conviction will be quashed. So we are joined at the hip, the investigator and the prosecutor, to make the prosecution. So we have prosecutors being the clerk of courts in the parish court, prosecutors in the DPP's office, Crown Counsel. We have prosecutors with state agencies like MOCA, FID, Integrity Commission, and we have any external attorney who has a fiat from me to prosecute. Now, how does the prosecutor prosecute? It is a wise and prudent prosecutor who makes sure that, especially in technical cases, you have case collaboration and case consultation with the investigator. It is an even more intelligent, astute, and wise investigator who makes sure that they never, ever subjugate their common sense to that demon ego. And excess of ego will neutralize common sense, because ultimately, even if you gather all the evidence that you believe is relevant, if certain things are not picked up, certain challenges are not picked up from day one, loopholes are not closed, it may still mean that you go to court and the prosecutor is given a lemon, so to speak, and the case falls apart. So for strategic and effective investigations, to determine what investigative tools are best, determining the way to proceed in addition to the substantive charges, for example, larceny, fraudulent conversion, whether we're going to have forfeiture proceedings, civil recovery, money laundering charges to be laid, or whether you have criminal charges that are to be laid, whether they are appropriate, what is most appropriate. Case consultation is very valuable. And let me be quite clear. For, I would say, the average prosecutor, and I'm going to include myself as the average prosecutor, Financial crimes to prosecute are not the most sexy topics that one likes to prosecute. And you have a lot of investigators, unless you have had specialized training and you have the particular proclivity in terms of being able, and some prosecutors have it, to really gather around and be energized by boxes of documents and papers. You tend to find for some investigators, some prosecutors, and indeed some judges, financial crimes are not particularly sexy. For some prosecutors, give us the run-of-the-mill murder, circumstantial evidence. Sometimes it gets very gory. Sometimes it gets very risky security-wise. But for some of us, nothing energizes you and gets the adrenaline going like the run-of-the-mill or extraordinary offense against the person. In respect of financial crimes, you have to, as a prosecutor, have a slightly different mindset in terms of the type of attention to detail and discernment that you must have in preparing your case, and in fact, collaborating with the investigators, especially if the investigators are more experienced in financial investigation than you as a prosecutor in prosecuting financial crimes. Now, I have here some investigative tools, and I'm not going to go into detail because I think you'll have my paper. You have under POCA, customer information orders, disclosure orders, orders to grant entry. You have search and seizure warrants under POCA, search warrants under the Financial Investigations Act. You have production orders and also accounting monitoring orders under POCA. So there are a variety of investigative tools. Investigators, you have to have that in your back pocket so that you are able to pivot depending on the challenge in, dare I say, lack of cooperation, whether telepathic or actual, that you will find on the ground, in the trenches. When you go to gather material, you have to be able to have this in your back pocket to converse and liaise with the prosecutor or prosecutors at your agency, and you have to be bold and decisive. There comes a time when cooperation that you are trying to get from persons who ought to assist you, especially in an entity that has suffered from fraud, there comes a time when you may find that you are just being, pardon me, being unforensic, you are getting some BS. You have to be discerning and be able to pick up the line of the delivery and adjust your stroke play on a dime, in a second. And if it is that you have to show, let me call it, that muscular rigor as an investigator, you must not hesitate. No matter, I tell people all the time, you will always get my smile, but in the twinkling of an eye, in the public interest, I do not hesitate to go for the jugular if I must. I will go for the jugular, get the conviction on the evidence, and be the first person to say to defense counsel, are you thinking of calling character evidence? But I have done the job. Now, you have civilian experts, which are also critical in assisting to connect the dots. Don't be afraid to go to these places and get the expertise. National Lands Agency, Tax Administration of Jamaica, Taxpayer Audit and Assessment Department, Quantity Surveyors, Forensic Accountants, Motor Vehicle Registry, NIS, National Insurance Scheme, Companies Office, reports from the regulator, like the FSC, and I say it with a smile. So it is important that you know exactly which expert to access which expert to get that critical statement, especially in assisting you to prove or to lay out what the protocols or the system ought to have been, so that in terms of the prosecution of the matter, you will now be able to show the tribunal of fact and law where you had the deviations, where you had the deflections. Now, the benefits of case conferences. And I always enjoy case conferences. I try to make sure that when I'm meeting with a task force, I inject some levity, because usually the case conferences take a long time. And in the public service, we may have a little tea, a little coffee, a little water, but it's very basic, because we are there, investigator and prosecutor, to make sure that we are on the same page, going towards the preparation of what will underpin a successful prosecution. Ladies and gentlemen, sometimes I find it amusing, and I am glad that we have, should I say, journalist extraordinaire / I nearly said not prosecutor, but defense counsel, Mrs. Dion Jackson Miller, in the virtual space. She's smiling now. I always say that it's so easy for people to say, why don't we have more prosecutions of corruption matters? Why don't we have more prosecutions of politicians or anybody else, people within the financial industry? But I say again, this is not CSI or Law and Order. We're not talking about a cartoon that you can wave a magic wand. I remember when my daughter was about 5, and there is this little cartoon called Fairly Odd Godparents. Oh, all the parents know it. And I said to her, Leah, look at that cartoon. Look at that. They have flushed the godparent down the toilet. She was coloring and she looked at me and said, Mommy, it's a cartoon at 5. So I say to the public, and I say to the naysayers, the prosecution of crimes, and especially financial crimes, it's not a cartoon, because you have to deal very, very much with what I call the human condition. Because very often you are investigating or you are prosecuting, and one of your witnesses or 2 of your witnesses were willfully blind. They knew what was happening in terms of the fraud. But whether because of, I call it, professional incest, or because they lacked the cojones, or because they were, or a third party connected to them was getting something out of it, they had remained willfully blind. So that particular individual, you have to be able to discern that person. But don't let them know that you're onto them. Because you may get a spate of, I can't recall. But they must not know that what it does to you. In fact, you don't even have to get that. Based on what you see of the system, you do not hesitate to do financial profiles on everybody. You trust only yourself. And even the persons who you think you can trust in that investigation, you trust but verify. Certainly that's how I operate. Don't ever be fooled by the smile. When it comes to the work, I don't trust. I trust myself or my colleagues at the office, or if I'm dealing with investigators, I trust but verify. And when it comes to the witnesses, I don't trust anybody. Certainly not in a financial crime case. I would commend that to you. There's a concept in literature called willing suspension of disbelief. Never willingly suspend your disbelief when you are dealing with potential witnesses. And even the complainants, you are guided only by the evidence. And that is why, as an investigator, you have to be so thorough. So what are the benefits of case conferences? The team gets the opportunity to settle the documentation that they have in their possession. This is important as it relates to disclosure. It's very disconcerting for a prosecutor in the middle of the trial. And I see my team here who are going to talk about a particular case in the middle of the trial, where you have 7, 8 accused, 7 lawyers, and it's very tension-filled, the case. And you have the investigator saying, oh, due to an oversight, we didn't give you this video that we have of the raid or the search that we made of the main accused man's premises where you collected so much documentary material. The prosecution, that is both the prosecutor and the investigator, we have a continuing duty of disclosure. So even if it is in the middle of the case and we get it to hand, we not only have to apologize to the court and be embarrassed, but we have to disclose it. And usually the court will pause the matter for a little while to give the defense, because the criterion is fairness. In terms of due process for the accused, that's how a prosecutor thinks. It is fairness. So you have to have a Pavlovian reflex action in terms of your professional conduct to be fair to the accused. Otherwise, it can be a ground of appeal later on. So please, please, please make sure, especially in a difficult case, that you have a case conference so that you can see all the possibilities in respect of documentary material. And with the documentary material, which usually underpins financial investigations, for a prosecutor, because when we are with you in that case conference, we are, let us imagine like a spreadsheet, an Excel, a big Excel sheet. So each of you are telling us about what is happening, what you have, so and so and so. But we are thinking possible offenses to indict, ingredients of the offense, admissibility issues, document A, which witness we are going to use to get it into evidence. And most importantly, what are the possible defenses that the accused will come with? How are they going to, that is the defense, you have to play devil's advocate as well, to seek to derail or assail the credibility of your witness? If there is a witness, number one, who may have credibility issues, where can you get evidence from to bolster that credibility of the witness, especially if it's a critical witness? And of course, the law on the area. So when you are talking to a seasoned prosecutor, certainly in financial crimes, the prosecutor is processing all of those factors as we are looking at the case all at one time. So we will be talking to you and you talk about an issue and immediately case law comes to mind. Oh, the Queen against so and so and so. In that case, and I encourage my prosecutors, get the case law and give it to the investigator so that they can read it, not only understand, but empathize with the prosecutor. So it's not that the prosecutor is being overly demanding. It is that we are already, because of our experience at first instance in trial and our experience in the Court of Appeal, we are seeing the potential issues and challenges like a breadfruit. But we must also see the solution as a matter of law. And all of this we are seeing at the same time, which is why we are able to make recommendations to say, you need to get another statement from so-and-so, get a further statement from so-and-so, organize your questions in a particular way when you come to the question and answer under caution. Do you have reasonable cause to suspect that that particular person may have been a part of the conspiracy? If such, when you come to speak, don't take a regular statement once you have the reasonable cause to suspect, because you're thinking, the Queen against husband and virtue, judges' rules. So all of these things You can have a conversation with an investigator and be thinking of no less than 10 cases, in fact more, and it just comes from your training and experience. So if you have a technical case especially, always have a case conference from day one. It helps a lot to smooth the way for an efficient and effective prosecution, which has been underpinned by timely disclosure, and most importantly, an indictment with counts charges that is tight and may put us in a position that it is the defense counsel on behalf of his client who comes to have a conversation with us in respect of a plea negotiation. Okay? Now, the team can assess in a fulsome way its strengths and weakness and strategy. Present strategy and future strategy. What is important is that all of us are au fait with what the case theory is or ought to be, and the potential offenses, and the fact that we have sufficient material to undergird the ingredients of the potential offenses. We would also say that just like prosecutors, it is good if investigators have non-legal skills, mental fortitude. You can't give up. You have to be focused. Be proactive, thinking outside the box, resourceful, emotional intelligence. I sometimes like injecting a moment of levity in a case conference when I say to an investigator, listen, we need to know everything about the suspect. And I won't mind if you're going to be so detailed that you are able to tell me the color of the toilet paper that he or she uses. That's how detailed you have to be, right? Sometimes even the sexual proclivity of the particular person. Because you may have relationships between the suspect and somebody within the organization that you are not aware of unless you dig deep. Because sometimes the particular individual on the surface may appear to be the sole suspect. However, if you dig deep, you may just see, looking at financial profiles, and sometimes hearing what a security guard or a low-level employee may hint that the particular suspect was in a relationship with a director in the company. And that may tell you that maybe she or he didn't get all of the money, but she was a conduit or he was a conduit. But you won't know unless you do thorough investigations. So not only sometimes of the professional life of your suspects, but where appropriate, the personal as well. So non-legal skills also, approaching work with intellectual and muscular rigor, trusting yourself, your experience, using time effectively to prevent dissipation of funds, amnesia from potential witnesses, disguising their role, and obstruction. Causes of fraud. What causes fraud to flourish? You can have breach of regulations, willful blindness on the part of the compliance officers in the organization and the regulators. Loose control mechanisms, which are flourishing, but willful blindness would cause it to flourish even more. Loose supervision, an inability or refusal to trust and verify by persons within the organization. No natural proclivity to cooperate, the proclivity of persons acting alone or with conspiracy with others to be unethical. So sufficient due diligence was not done by the company before they hired the particular person, or they do not have human resource protocols that give sufficient rigor in the due diligence process. What happens when there is poor investigation? I don't have to tell you. Remember, the presumption of innocence is the most important thing in the criminal law and cannot be ignored. Wilmington. Burden of proof, which is a very high one in criminal matters, rests on the prosecution. The defendant has nothing to prove. It is the prosecution who has to prove the case and prove the elements of the ingredients beyond a reasonable doubt, or until the tribunal of fact is sure of the guilt of the accused. If there is poor investigation, then you will have gaps in the prosecution's case that cannot be closed during the trial and would then cause a reasonable doubt to not only appear but to flourish, and that would cause the acquittal. The prosecution in these cases will be forced to take the role of a magician, or in a circus, a performer jumping through hoops. And that is why I'm saying, again, it's unfortunate that members of the public, even some members of the media, I would like to think that one of the contributions that I have made as DPP is to so open up the workings of the office that a lot of journalists, some of whom have done law, but a lot of members of the public, even people in social media, now recognize the whole issue of the difference between proof of a case in the should I say, the court of public opinion versus proof of a case in a court of law. And I think that has been done, because when you check it out, everybody feels that they are a good prosecutor or a good police officer. So that is good. It means that they are listening. Successful prosecution requires having cogent, reliable, and admissible evidence from documentary material or oral evidence from a witness, what we call viva voce testimony, working together as a team, ensuring that the prosecutor has all the available material. Sometimes it's difficult, it is hard, it may appear to the investigator that the prosecutor is cracking a whip. Yes, we are cracking a whip, because when we stand up in court, we are the one who is embarrassed, although the prosecution is the investigator and the prosecutor. But who does everybody see? I often tell my colleagues at the DPP's office, I am accountable, I know, for every decision and every case that is done by all of my 57 lawyers who act in my name. But what is unfortunate, if anybody messes up, the public only sees my face, whether with a smile or no smile. And some members of the media even have me in different, cartoons. Thankfully, they draw me as being slim. But still with the open space in the teeth. But it is my face that is seen. And I embrace the fact that as DPP, being the holder of the office under the Constitution, I am accountable to the public of Jamaica that we serve. And this is how you, as the investigator, you have to see it. And we see it together. It's not about the public serving us. We serve the public. So, if we have to stretch, if we have to work nights to get the material, especially in a high public interest matter, the credibility of the administration of justice is at stake, then all of us have to accept the self-inflicted crack of the whip to make sure that we get the job done. So, you have different types of financial crimes, and I don't have to spell them out. You all are aware. Larceny of a clerk or servant, embezzlement, fraudulent conversion, obtaining money by means of false pretenses, obtaining credit by fraud, conspiracy to defraud, embezzlement, falsification of accounts, and of course you have the POCA offenses. And where we want to get to in respect of the POCA offenses is to be able to have a reflex action on the part of investigators, not just financial crime investigators, but investigators generally, to want to do financial profiles, and also on the part of prosecutors, especially in the lower courts. And we have been working on them to indict at least at account where appropriate for money laundering offenses. So I'm wrapping up now just to say that other offenses: acquiring, possessing, dealing, retention, engaging in transactions relating to criminal property, financing of terrorism and the proliferation of weapons, financing of organized crime, money laundering, all these are factors and crimes that are occupying us now, and I'm happy that certainly since the time I have been DPP over the last few years, we have seen the evolution of legislation through amendment, and it will continue to assist investigators, giving you the tools, but most importantly, making sure that Jamaica is right up there in cutting edge in terms of the prosecution, investigation, and prosecution of financial crime. There is no room for all of us within the administration of justice to operate in silos. There is no room for turf tension. We all have to remember, for the sake of the public interest and the interest of justice, united we stand, divided we fall. At the end of the day, we have to do what is right as professionals so that Jamaica, land we love, can flourish as a place to do business, to work, and to have a positive future. Thank you.